classes. And Thursday, I have to deal with the evaluation forms that I'll pass out, but I have to be out of the classroom when you fill them out, so I'll have to leave time for that. I posted yesterday that we will have a review session a week from today, right here, same time, same kind of format as we did for the midterm. So don't let any of your questions go unanswered for that time. And the final is May 9th in 100 Lewis, I understand. We can do chemistry experiments. It starts at 11:30, and the format will be very, very much like the midterm, and the length will be very much like the midterm, so you'll be out of there in 45 minutes. But don't come late, because I'll collect all the papers and go home by 1 o'clock for sure. So more on that later. So we'll finish up today and Thursday with the attempts by Congress to regulate the internet. What's so funny? Yeah. Cumulative. Oh, good question. Yes, but. Yes, but. It will very, very heavily emphasize the material since the midterm. It's just that I've said this before, I can't let you forget the big marquee items. How can you get out of this course and not know what New York Times versus Sullivan's about, or the Pentagon Papers? What was that? Yeah. Okay, the internet is a new medium of communication that the Supreme Court had never encountered. And remembering that they treated broadcast so differently from print, and cable differently from broadcast from print, what are they going to do with the internet? So one of the first things to ask, and let me ask you, is what are the characteristics of the internet that affect the propriety, the reasonableness, the need for government regulation of this medium? What's different about this medium from the others that we've looked at that are relevant to the extent to which government should be regulating it? Aaron?
On the internet, you have a reader has a lot more power to respond to anything, or message or comment that you're supposed to.
You know, so a reader can respond to what's there, and that's different from writing a letter to the editor? It's immediate, and it's right there for everybody who saw the initial article to read.
And it's not always, when you write like to editor, that's, I'm assuming they have rights to publish that, for everybody to see.
That's an editorial choice, whether to use the newspaper's space, limited space, to print letters. Sure, that's an editorial choice. It's not. Yeah. So your ability to respond to it, and how does that affect whether it's right for government to be regulating the media?
I mean, there could be things that are said on the message boards that could offend people.
And therefore the government has a role in regulating what's put there?
Yeah.
So a greater need to regulate content on the internet than in newspapers? You'd conclude from the fact that every irresponsible teenager can let loose on the internet means that government ought to police it. More than newspapers. No, I'm just wondering about the characteristics of the internet medium that would either say government should be regulating this or government shouldn't be regulating this because of these characteristics. Mm-hmm. Yeah. No, wait a second. Isn't that two ideas? Everybody can be a publisher. Which way does that cut? And therefore government has a role in policing what's out there? Yeah. And the other part of it was they can post copyrighted material, infringe somebody's copyright by posting that. And does that call for government regulation? Yes? Alexia?
I think one of the biggest differences is anonymous with that. So you don't know who's saying what to. There's the whole point where children can go on the internet and adults can protect the children. And some people on camera can. Also, I feel like there's kind of, when you go into a store for kids and try to buy something and also too, it's like obvious that you're underage and they won't sell to you, but on the internet, no one knows your age, you're just like a computer. So like you can access things that children shouldn't normally be allowed to access. And like that was kind of a lot of the stuff they're bringing up, like why shouldn't you make it illegal, like illegal everywhere else, illegal on the internet, like kids to access porn or like other things.
And therefore the government has a legitimate role in policing content on the internet? The kid thing reminds me of the New Yorker cartoon that I'm sure you've seen. One dog talking to another dog and saying, on the internet, nobody knows you're a dog. See?
Also just going back to the idea that anyone can publish online. In traditional media, publishers have a role of censoring the content, but online there is no publisher as the person posting it, so the government has to set it from that child pornography production, for instance. In traditional media, publisher, you can't put it in a magazine, what are you doing? But online, the only person there can put that is.
Yeah.
Just to show you some extent, following this flow through magazines like this, the regulated presence only works on the internet, and we are, like, as presumably intelligent people should be able to discern. I think that without information, and valuable nature wouldn't be as much of a need for so much regulation, because when there's so much information out there, doesn't necessarily be regulated themselves for themselves. Whereas with the press, maybe there needs to be some information because that's platform has a way to reach people where people can interpret it.
I mean, this phenomenon, which is, I think, unique to the internet, that it's not communication from a big corporate publisher, from the one to the many, which at least in the broadcast context favors government regulation. It's from the many to the many. And I'm trying to figure out which way that cuts in terms of whether government has a legitimate role. Tina?
I'd say it is government having a role with the internet as compared to other mediums is widespread, but not as pervasive. You choose to connect to the internet. It's not something that kind of blacks itself into your own or assaults your ears or eyes. It's hard to find something that you're not.
Yeah, it's not as pervasive. I mean, it's practically as pervasive these days, isn't it, as radio and television? And I thought you were going to borrow the word from Justice Stevens in Pacifica, that the medium is not intrusive. Intrusive in the sense that, oops, all of a sudden they're assaulting me with this material. Krista? Yeah. Tim?
But at the same time, there was a study a couple months ago, probably not highly accurate, it's posted on the internet, but it said if you were to turn safer thoughts or anything, like, that case said you very more. It wouldn't matter what you said.
I had a class with one of the statistics professors. It's a class on
Yeah. And what did you learn there?
it's not about points.
Oh.
Yeah.
Here's a medium with practically no barriers to entry, right? Unlike having to acquire a broadcast license, unlike having to invest billions of dollars in printing presses and distribution networks and so on, here everybody can be a publisher instantly. And it sounds as though you think that that calls for government regulation rather than the opposite. That we assume that all of us publishers are irresponsible and going to post salacious, libelous, copyrighted material that we have no right to do, and that therefore the government better watch us when we're on the internet. That it's decentralized, in other words, not a big publisher dominating the industry, that it's interactive, that we can talk back to it. I guess you can make the case that that calls for government regulation. I would have thought the opposite, that it's interactive, that when somebody says something that we think is untrue or unfair, not well informed, we can correct it right then and there to the same audience. Why does government have to be involved in that? How would government be involved in that? What would government say? You can't post that. We're going to monitor everything and punish those who say things that aren't appropriate. That it's not really intrusive. You have to take affirmative steps to gain access to this medium. It's not like radio and television that drops in your lap. You have to take some steps. It's a little harder for children to deal with, I guess, than turning on the television set. What about the fact that it's not geographic, that it's everywhere? Uh-huh. Mm-hmm. So when all of those pornographers in Germany are polluting our children, American children, diluting, flooding them with pornography, there's nothing we can do about that here. And you need some kind of international enforcement. Yeah, that's one implication of it. Though the fact that it's everywhere does affect whose law applies to it. Now, with our 50 sovereign states, are the states going to regulate the internet and say what can appear here and there? It's not like a newspaper that has a certain geographic market. It's not like a broadcaster that has a certain geographic market, and that only. It's that it's every place. And I don't know how that affects the extent to which government should be able to regulate the medium. These characteristics of the medium ought to be taken into consideration, because that's what the court told us that we're supposed to do in deciding the extent to which the First Amendment protects communications on any medium. Look to the characteristics of that medium. And then Congress, confronted with this unregulated, totally unregulated, new, powerful medium of communication that everybody can participate in, the most democratic medium of communication ever invented, Congress panicked. And, oh my God, what are we going to do? We have to do something about this. And so naturally, they went after sex on the internet. And they've tried several times to deal with that. The first effort was the Communications Decency Act of 1996, which virtually everybody in the Congress voted for. The Communications Decency Act is, in my view, the most sweeping restriction of the speech of ordinary citizens that Congress has ever attempted, including the Sedition Act, because this applies to everybody. It's global in its reach. And the point of the law was to protect America's children from exposure to sexual material on the internet. It had the two main provisions. Section 223A made it a federal crime punishable by 2 years in prison and a fine to say anything, quote, indecent online, knowing that the recipient of your communication, think primarily email, knowing that the recipient of your communication is under 18 years old. That's one provision. And the other provision was the display provision, which made it a federal crime, also punishable by 2 years in prison and a fine, to display on the internet in a manner available to people under 18 anything that is, quote, patently offensive. And you have in one section the term indecent, and the other section the term patently offensive, and no definitions of either. It might be reasonable to guess that what Congress had in mind in using the word indecent is indecent as used in broadcast regulation by the FCC. Maybe, that's right. Well, then what's patently offensive? Isn't that the way the FCC defined indecent, just with 1/3 of the obscenity definition? Well, the law, as soon as it was passed, was greeted with a lawsuit brought by the ACLU and a bunch of other organizations, many of them who communicate online, a lawsuit against the Attorney General of the United States. Janet Reno was the Attorney General under President Clinton. She was a law school classmate of mine, by the way, and I can't believe, knowing her, I can't believe that she could believe the arguments that were made by the Attorney General's office in support of this law. The ACLU, when they sued, the plaintiffs when they sued, did not challenge the prohibition in the law of obscene material on the internet. only the indecency and the patently offensive provisions. And the Communications Decency Act, of course, put an uncertain but certainly wide net of criminality around a lot of internet communications. The law was not limited to commercial speech, speech for commercial purposes. You remember the phone sex law, the dial-a-porn law, was involved using indecent or obscene language on the telephone for commercial purposes. There's no such limitation here. And because the Congress left out the other two parts of the obscenity test, prurient interest and no literary, artistic, political value and so on, you're talking about material that does not appeal to the prurient interest, like saying shit, and material that may well have significant literary, artistic, and other value. And you also have built into the patently offensive provision was that this is going to be judged by contemporary community standards. What community? The worldwide medium. What community is going to judge this? And the ACLU pointed out the kinds of speech that are prohibited by this law, including, for example, the appendix to the Supreme Court's decision in the Pacifica case. Remember I said tuck that away? Justice Stevens, when he wrote the opinion in the Pacifica case involving George Carlin's 730 words monologue, attached as an appendix to the filed opinion in court a transcript of Carlin's monologue, which is online, of course. You get it on the Supreme Court website. But there is the example of indecent or patently offensive material, as we've known it under our law. So it would be illegal to post the complete Supreme Court decision in the Pacifica case. It would be a crime to post the Attorney General's report on pornography. Back in the Reagan administration, Attorney General Ed Meese headed a Attorney General's commission to study the pornography phenomenon in the United States. And they discuss in sometimes graphic terms what can be seen on various videos and so on, using some of the language that's used there. So it would be illegal to post the Attorney General's report. Magazines like Wired, for example, and Rolling Stone that appear both in print and online would be fine in print. They can use Carlin-esque words, no problem if they're in print. But as soon as they press the send button and it's online, bingo, felons, subject to 2 years in prison for putting that material online. The plays like Tony Kushner's Pulitzer Prize-winning Angels in America, a wonderful play, full of raw language and sex, and it would be a crime to post that online. An email from you to your lippy younger brother, who happens to be 17, saying, look, shithead, you better get your act together if you're going to get into prison. That violates the law. 2 years in prison and a fine. So the reach of the law was unbelievably wide. And the question is, what's the Supreme Court going to do about it? They're confronting this brand new medium of communication. And assigned to write the opinion is John Paul Stevens, author of Pacifica. He knows how to deal with new media. And he did a masterful job in the opinion in Reno versus ACLU. He just said, here's how the internet operates, and he explained it in common sense terms. He was then 77 years old at the time he wrote the opinion, and he explains all this. He says, navigating the web is relatively straightforward. And he had it all down. He understood this medium, and the court didn't botch it this time out, and the decision is a real charter of liberty for the internet. The first question that the court had to resolve is the question of what level of First Amendment scrutiny should we give to this medium. The court, Justice Stevens, cited the Red Lion case for the proposition that each medium of communication has its own characteristics, and those characteristics affect the level of First Amendment scrutiny that we apply to it. The government, Janet Reno's lieutenants, came in and argued to the court many of the things that you identified in talking about the characteristics of the medium, and said that, well, relaxed scrutiny of the kind that the court used in Red Lion and in Pacifica is appropriate for this medium, not strict scrutiny. And the court said, and the government argued that what they call the indecency problem was worse on the internet than it was on broadcast. And that's because, the government argued, with the internet you don't have commercial sponsors the way you do on broadcast, companies who don't want to be associated with dirty material, and not having those people to censor what's put up on the internet makes it a more perilous place for America's children than broadcast. No commercial sponsors were worried about their image and being associated with what's put up there. And then the court looked to the characteristics of the internet medium that it identified, and that had been identified in Red Lion and in Pacifica as justifying government regulation of the content of broadcast. What were they? Scarcity. Spectrum scarcity. How does that apply to the internet? Not at all. No such thing as scarcity with regard